Services Manager here at Metro, and I'm so glad to see such a big crowd for this session today on copyright. And I've been trying to get Greg to do something like this for quite a while, so this is like a good showing to hopefully influence him to maybe consider doing it again in the future. So I'm just going to introduce Greg and then hand it over. Greg Cram is the Associate Director of Copyright and Information Policy at the New York Public Library. Since joining the library in 2011, Greg has endeavored to make the library's collections broadly available to researchers and the public at large. He is responsible for developing and implementing policy and practices around the use of the library's collections, both online and in the library's physical spaces. He has helped steer projects through a maze of complex intellectual property issues, including the recent release of more than 20,000 high-resolution images of public domain maps. Greg has represented the library in advocating for better copyright policy, testifying before Congress about the doctrine of first sale in the United States Copyright Office about orphan works. So with that, Greg.
Does this mic sound okay? Okay. So, thanks to Metro for hosting, and thanks to Anne for the nice introduction, and thanks to you for coming on such a gross afternoon. So, keeping up with copyright, I'm going to go through a roadmap and talk about where we're going to go for the next hour, and then we'll open up to questions at the end. We'll start off with a basic copyright overview. Some of you are copyright experts, and some of you may need a little refresher, so we'll go through a kind of an overview of copyright law. We'll go through some of the litigation updates, especially in the Google Books case, the Hadi Trust case, and the Georgia State case. We'll go through a little bit of the legislation updates that have been going on, both local and national. Some important copyright issues are happening at both levels at this point, so good to know about both. Then finally, we'll wrap up with rights metadata and the Digital Public Library of America. And we'll talk about some interesting happenings going on that may impact some of the work that you do. But first, I have to do this little disclaimer. I'm not here representing MIPL or speaking on behalf of the library. I'm here in my personal capacity. Nothing that I'm about to tell you is legal advice. You shouldn't take it as such. If you like legal advice about your particular situation, feel free to engage legal counsel. There we go. Okay, so let's do a little copyright overview. So raise your hand if you created something protected by copyright today. Good, that's what I expected. So did you do any of these things? Did you post text on Facebook, write a tweet, write an email, draw a doodle, take a photograph, write a paper? If you did any of those things today, you created a work protected by copyright. So all those hands that weren't up should have been up. Copyright is everywhere, and it's pervasive in everything that we do. At least it feels like that to me. But it hasn't always been that way. At least the perception hasn't always been that way. In 1976, when the 1976 Copyright Act was passed, the New York Times had this article and had this to say about the importance or lack thereof of copyright, and said, after 15 years of debate and discussion and a lobbying effort that was the bread and butter of hundreds of lawyers, Congress has finally reviewed the nation's copyright law for the first time since 1909. No firecrackers went off when the compromise bill cleared Congress, and no bells are likely to ring when President Ford signs the measure. The matter is simply too technical, complicated, and cumbersome for anyone but specialists to get very excited. While the legislation will have an immediate and direct effect on basically a small segment of society, there could eventually be a much broader and lasting impact. From the New York Times, small segment of society. It's kind of funny to read this article today because copyright is so pervasive in everything that we do. So they were foreshadowing a little bit, but they were certainly downplaying the important role that it plays today. In fact, it's such an important role that the libraries are creating more and more of my types of positions. There's about 35 of us in the country who do what I do at a library. I think I'm the only one at a public library that's not the Library of Congress. So not many of us out there, but it's an increasing, there's a number of us there's an increasing job market for us. And here's why. So in FY11, researchers accessed 1.6 million physical objects in our collections at NYPL. So 1.6 million, that's an increase over years past, and it's a trend that we keep seeing increasing over time. But for the same time period, people accessed over 127 million digital items. That's an 80 times greater access of digital images than physical objects, 80 times. And that's growing exponentially. So for a long time, for hundreds of years, libraries were focused their energy on physical objects. These are our stacks under NYPL, but now there's an increasing focus on digital access. Our patrons are looking to access our content at the doors, or at the online door and not necessarily the physical door. So to meet that patron demand, libraries are increasingly digitizing their own collections. This is Pete, our head photographer at NYPL, and he's photographing a photograph and photographing it at a high enough quality and resolution that we think it's going to be preserved and that we can make it available online. All right, so where does copyright come from? It comes from the Constitution. The Constitution says the Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the Constitution says that Congress shall have the power to do this, to create copyright law, and Congress so has. They've passed 4 major copyright bills since the founding of this country, and the latest one is the 1976 bill. So let's talk about the scope of protection. What does copyright protect? Well, we got a little bit of a hint when I asked the question about who's created a work protected by copyright, but it's almost easier to ask this question in the reverse. What does copyright not protect? Copyright doesn't protect ideas, procedures, processes, systems, methods of operation, concepts, principles, or discoveries. Essentially, it doesn't protect ideas. It only protects the expression of those ideas. So copyright protects original works of authorship fixed in a tangible medium of expression. Original works of authorship fixed in a tangible medium of expression. So let's break that down a little bit. Original works. What's an original work of authorship? Well, original is kind of a weird word. It's tough to describe sometimes, but the way that I like to do this is by using this guy. In 1996, in a PBS documentary called The Triumph of the Nerds, he was asked why Macintosh was such a success. I remember this is 1996, and here's what he said.
Trying to expose yourself to the best things that humans have done, and then try to bring those things in to what you're doing. I mean, Picasso had a saying, he said, good artists copy, great artists steal. And we have, always been shameless about stealing great ideas.
We have always been shameless about stealing great ideas from the great Steve Jobs in '96. He didn't always feel that way. In fact, in 2010, Apple sued HTC for patent infringement. In a press release, Steve Jobs said that we can sit by and watch our competitors steal our patented inventions, or we can do something about it. We've decided to do something about it. We think competition is healthy, but competitors should create their own original technology, not steal ours. Quite a shift in 14 years, but that's the problem with originality sometimes, is that sometimes you're always referencing other things. But originality tends to mean that for something to be original, there has to be a modicum of creativity. What do I mean by that? A small amount of creativity is what I'm talking about. Let's think about a phone book, right? This is a list of facts. These facts aren't original. There's no, it's just a list of names and addresses and phone numbers, so nothing original here. Therefore, copyright really doesn't protect this phone book, except there's a very small, thin copyright sometimes. There is a little bit of creative expression in this phone book. It depends on somebody had to decide how to lay the things out and what colors to use and what font to use, and maybe that's a little bit of a copyright, but it's really, really thin, if there is one. All right, so copyright protects original works of authorship fixed in a tangible medium of expression. What does fixed mean? Fixed is pretty easy. This is fixed. This is fixed. And even digital things are fixed. Courts have told us that things created on computers are sufficiently fixed for copyright purposes, and therefore digital works can be protected by copyright. So in short, copyright protects a number of different things. It protects books, fine art, music, movies, but ultimately the format of the expression doesn't matter. So long as the expression is original and it's fixed, it can be protected by copyright law, and it happens automatically. A copyright can also be layered in works. For example, in music, in sound recordings, there's usually 2 copyrights involved. The first copyright is in the sheet music, in the composition, and the second copyright is in the music. So in this case, there's a copyright in the sheet music, and there's a separate copyright in the performance of that sheet music. And this is some nights for fun. And I hope you all just got woken up a little bit. So 2 copyrights. So there can be multiple copyrights in a single expression. Okay, so what do you get? You're a copyright holder, you've written your Facebook post, you've taken your photo. What rights do you get? Well, under copyright, you get a set of exclusive monopoly rights. You get rights that the rights holder gets when they own a copyright, and sometimes we call those things a bundle of rights. That's usually how you refer it, or we hear it referred to. It's a bundle of rights that the rights holder gets when they create a copyrighted work. Sometimes we call it a section 106 rights. Section 106 is the part of the Copyright Act that describes these things, but it's a right to do something and prevent others from doing something. You get the exclusive right to do certain things and prevent other people from doing it. So for example, you get the right to reproduce copyrighted works, so think about your copier. You have the exclusive right to do that. You have the exclusive right to create derivatives. Think about the Hunger Games. This is a classic derivative. We have the movie based on the book. You also get the right to distribute works. Think about passing things out. And you also get the exclusive right to publicly display and perform your works. So out my back window, we can see this in the summer. This is in Bryant Park. There's usually a movie night in the summer, a couple movie nights, and HBO is the main sponsor, and they play movies. They publicly display those movies, and those movies, that right to publicly display movies is a protected right that only the rights holder can exercise. So here are the rights you get as a copyright holder. You get to make copies, make derivative works, distribute those copies, publicly perform that work, and publicly display that work. Those are the 5 rights that you get. How long do you get those rights for? The duration today is life of the author plus 70 years. Life of the author plus 70 years, but that's changed over time. In fact, it's constantly growing. From 1790, from the first Copyright Act, it was the maximum term was 28 years from publication. You had to do 14 years, and then you got another 14 years if you actively did something. So 28 years max, all the way through today, where it's life of the author plus 70. And this is out of proportion. Life plus 50 is certainly longer than 56 years. It just made the chart look a little funny when I did it that way. So copyright, it continues to get longer and longer and longer, and today it's life of the author plus 70. So I've been saying all these things, that these are exclusive rights that only the rights holder gets to take advantage of, but there are some exceptions and limitations to that. So there are some things that people can do, that users can use copyrighted works in some situations without prior permission from the rights holder. And we call these things exceptions and limitations. There's a number of exceptions and limitations. Don't have time tonight to go through all of them, but I'm going to highlight 2 because they're important for later. The first is fair use. And fair use is kind of the biggest exception that everyone seems to be very, very excited about, including NYPL. And the exception is that it's a balance between the author's rights, the rights of the copyright holder, with those of free speech and social benefits. So you're balancing the needs of the rights holder to protect their work with the need of society to ensure free speech and to create socially beneficial uses of those copyrighted works, to advance the progress of knowledge that the Constitution tells us that the point of copyright law is. So there's 4 factors in fair use, and we'll go through them quickly because we'll go through them again later when we go through the cases. The first one is the purpose and character of the use. How did you use the other person's copyrighted work? Did you use it for commercial purposes, for educational purposes? Was your use transformative? Did you use it in a way that was not intended by the copyright holder? Did you make a comment or criticism of that thing? What was your purpose and character of the use? What was the nature of the original work that you used? Was it highly creative? Was it unpublished? Was it mainly factual, like the phone book example? What was the nature of that work? The more creative it is, the more likely we are to protect it and protect that use and think of the fair use as less valuable in that situation. How much did you use? Was it appropriate for the purpose you were trying to make? Did you take the most important bits out of it, or did you just take a small amount that wasn't the most important thing? How much did you use in relation to your use? If you used just enough, then that's likely going to be finding in favor of fair use. If you used too much, if you took the heart of the thing, that might favor a finding against fair use. And the fourth factor is market impact. What was the impact of your use on the market of the good? So if you, for example, digitized the Fun soundtrack or the Fun album and made that thing available online, are you destroying the market for the resale of those tracks? Probably. So it's probably going to be a significant impact on the market of those goods. So let me show you what this looks like in practice, because these are really high-level concepts and it's sometimes hard to get it in practice. Here's an example. So this is a portrait of Demi Moore while 7 months pregnant. The photographer is Annie Leibovitz, certainly an internationally recognized photographer. This was published in Vanity Fair in August of 1991, and the photo is instantly acclaimed and becomes part of the cultural zeitgeist. And I'm sure you've seen many knockoffs of this over the years. But this was my favorite knockoff. In 1993, as part of an advertising campaign for a very satirical movie, Naked Gun 33 1/3. How many people have seen it? Hopefully good. Okay, good. So people know what it is. The Paramount Studios creates this poster, essentially to mock this poster. So Annie Leibovitz sues, claiming copyright infringement, and Paramount claims that its use is a fair use, that it's protected by the fair use doctrine. Paramount claimed that its copy of the photo was a parody. It was meant to make fun of the original photo. It was meant to comment on the original photo. And they argue the parody is important to the free exchange of ideas and criticisms, and therefore should not be barred by copyright. Annie Leibovitz should be able to take the criticism and should not be able to use copyright law to stop these kind of photos that are more mocking or more parody. The judge agreed and decided that this is a fair use, that this is a balance against the author's interest in protecting free speech. I mean, that free speech is more important in this case than the author's interest in preventing others from making copies. Therefore, it's determined to be a fair use. I'll show you one more. Hopefully it won't blast your ears this time. So this is a video done by DJ Earworm. Every year he remixes the top 25 songs of the year. And puts it together in this compilation. I'm not going to say much more about it. I want you to watch it and tell me what you think. All right, what do you think? Do you think these uses, this compilation of 25 videos is a fair use? Let's take a rough guess. How many hands think that it's fair use? Okay. So I think it's a fair use. I think he's taking snippets of others' works and recontextualizing them, making a new work out of it. That's what I think, but others certainly disagree with me. That's okay. It's the whole fun of fair use. All right, one more exception limitation. Libraries and archives. So libraries and archives get a special exception. It's the section 108. We call it usually the libraries and archives exception. So in recognition of the important and special role libraries play in society today, Congress gave libraries a special set of exceptions. These exceptions are key to library services, such as copying things for preservation, copying in response to patron requests, making copiers, computers, and printers available to patrons, even permitting some very broad uses of very old orphaned works. Very important for libraries and used by libraries today, including NYPL. We use it every day. It's wonderful. Okay, end of copyright 101. Let's get into the litigation update. And we'll start with the Google Books project. This is one of the carts that was down in the bottom floor of NYPL, ready to go out to Google to have books digitized. So Google Books project started in 2004 with lots and lots of fanfare. The press release of the original announcement says that Google's mission is to organize the world's information, and we're excited to be working with libraries to help make this mission a reality. The libraries of Harvard, Stanford, Michigan, Oxford, and NYPL join with Google to digitally scan library books and make them searchable online. So NYPL was an original partner to this arrangement. And what this arrangement was at the beginning was the libraries had books they wanted digitized, but didn't have the means or mechanisms to get them digitized at the scale they did. Google did. So libraries sent their books to Google. Google then scanned the books and created two copies, digital copies. One went back to the libraries, and one went to Google to drive its search. We'll talk about the copies that went to the libraries in a little bit, but I want to focus on the copies that Google uses. So Google's digitized roughly 20 million volumes at this point, with another 10 million volumes to go. The primary goal was to use the text as the basis of a search engine. So they ran a search. I ran a search with the terms fair use, copyright, and the New York Public Library because I'm super original. And these are the results that I got. I got a set of results that included the New York Public Library desk reference from 1989. When I clicked on the desk reference, I'm given about this book page, and given the date, 1989, I know this work is in copyright in the U.S. And NYPL at this point we haven't put a Creative Commons license on this, so I know it's in copyright, and I know that Google doesn't have the right to display it. So I know Google, I know this thing is in copyright, so Google can only display snippets of this work. Here's what the snippets look like. Google displays the keywords that I used in the search and where the words fall on 3 pages within the book. And Google takes security measures to make sure that the snippets can't be manipulated so that the entire work can be exposed through searches. For example, you can't search use on the last word on the first snippet and see the rest of the next paragraph. It's impossible to see the entire book through that mechanism. So the first use was to be the basis of a search engine. The second use was kind of an interesting side use. It enabled some interesting humanities research. It allowed researchers to do searches on the entire corpus of digital books, books all the way from 1760 all the way through 2000, actually even later than that. So this is one example of it. This is the Ngram viewer. And what I did was I searched 2 phrases to see how they were used. The first phrase is the United States are. That's the red line, if you can see it. You can see, based on this chart, that the United States are is the accepted phrase, the most popular phrase, to describe this country from 1776 to 1886. And that implied that the states are loosely grouped together. It's a plural, the United States are, so it's more plural. But you see a shift where the blue line starts to tick up. And this is after the 1870s, 1880s, to the United States is. So we just start describing the country as a single unit instead of a split unit. Coincidentally, the Civil War was 1861 to 1865. It may have something to do with why in the 1870s and 1880s we start describing the country as a single unit. Interesting humanities research can come out of this. All right, back to the snippets. So rights holders sued Google in 2005. They alleged that Google infringed its copyrights by digitizing the books and displaying the snippets. Google argued that the scanning and displaying of snippets is protected by an exception and limitation, namely fair use. And the question from the beginning was whether Google's digitization and display of snippets like this were fair uses. So we've had a couple of decisions on it. But let me walk you through our federal court system before I get there. Just a quick review of the federal court system here. There are 3 main levels within the U.S. federal courts, and I'll give you a very, very brief overview of each. We'll start with the district court. There are 94 district courts in the United States. Each state has at least 1 district. New York is big enough that we have 4 districts, including the district you're sitting in now, which is the Southern District of New York. Trials happen at the district court level, and most of the motions happen at this level. If a party disagrees with the district court's judge's decision, the party can appeal to a higher court, and that court is the circuit court. This country is divided into 11 geographic regions or circuits, and each region has its own circuit court. You're sitting in the Second Circuit today, and if you are still not happy with the circuit court's decision, you get to appeal up 1 level, and that's to the Supreme Court. So the Supreme Court can choose to hear whether it wants to hear an appeal or not. What the Supreme Court decides is binding on all of the courts below it, and it's the final judicial word on a case. The only way to overturn a Supreme Court opinion is to have the Supreme Court do it themselves or have Congress pass laws or make a constitutional amendment to fix it. All right, again, we start at the district court, we go up to the circuit court, and then we go up to the Supreme Court. If you get nothing else from this little civics review, just remember that there are 3 levels of courts in the federal system, each more important and influential than those below it. You will see this slide again. Okay, so after 8 years of twists and turns with Google Books, we finally got an answer on the pivotal question of whether Google's uses, displays of snippets, and digitization were protected by fair use. On November 14th of last year, Judge Chin issued his 30-page opinion. And he wrote, "In my view, Google Books provides significant public benefits. It advances the progress of the arts and sciences while maintaining respectful consideration for the rights of authors and other creative individuals, and without adversely impacting the rights of copyright holders. Therefore, Google Books is determined to be a fair use." Big opinion, took us a long time to get there, but the district court judge says it's a fair use. Within, I think, an hour, we got this from the Authors Guild. The Authors Guild issued a statement that says that it plans to appeal the decision immediately, and in fact it did. The rights holders were incredibly frustrated by the loss of this at the district court level and immediately appealed. So next steps in this case. So we've gone from the district court level, now we're in the Second Circuit, so we're up to the circuit court. And on December 3rd at 2 p.m., you can join me at the Second Circuit, and we will watch the oral arguments in the Google Books case. Oral arguments will happen on December 3rd, and then we expect an opinion from the Second Circuit within the next year, 6 months to a year. The way this case has been going, probably lean closer to the year. So December 3rd, 2 p.m., I will be there. I hope you will be too. All right, next case, Authors Guild versus Hadi Trust. So I told you about the library copies, and we'll talk about exactly how they were used here. But this suit was filed in 2011. Hadi Trust is a partner of Research Libraries. The partnership began back in 2008 with the goal of preserving digital assets. The primary digital asset came from the partnerships with Google. So if we go back to this, libraries had books they want digitized, send them to Google, Google digitizes them, sends the copy back to the libraries. But in this case, the libraries really couldn't handle the volume and the preservation needs of these digital files. And in fact, there were efficiencies in aggregation, and they wanted to make the books accessible to a broader audience. So instead of hoarding the copies locally, they ended up contributing them and creating this thing called Hadi Trust. Hadi, by the way, means elephant in Hindi, so they never forget. It's a preservation structure. Hadi makes many uses of in-copyright works in various ways, and I'll walk through the 3 that are most relevant for this. The first is they use the digital assets to drive a search engine, much like Google does. The search engine allows users to see how many times a particular word or phrase appears in a book if the book is in copyright. So in this example, you can see, if you look at the example, it'll tell you how many pages, where it is, how many terms match on a particular page. Note that Hadi doesn't show snippets. Important distinction between the two. Google shows snippets, Hadi does not. Second use that Hadi uses is to use the copies to support the blind and print disabled. It supports access to the corpus of digitized text by digitizing the text and converting it to a format that's accessible for blind and print disabled users. Third, Hadi makes use of the copies to make replacement copies for partners when the original is lost, damaged, or stolen. So Google digitized the book. If the book was damaged in NYPL, we could retrieve our copy back from Hadi and have a preservation copy to have on site. So Hadi is sued in 2011 by the Authors Guild, alleging that all of those uses were infringements of copyright. 2011 lawsuit. At the trial court level, a federal judge determined that all 3 uses that I just described are fair uses. All 3 are within the bounds of copyright, that all 3 were purposes that Congress intended for users to make of these things without requiring permission from the rights holders. So the Authors Guild appeals immediately, and we go to the circuit court. The decision was immediately appealed to the Second Circuit, where a panel of 3 judges heard the appeal. And on June 10th of this year, a panel of judges issued their opinion. They took a close look at all of the 3 uses I described and came up with the following. First, the court held that Hadi's use as a full-text search was a fair use. The original purpose of the text was to be read. Hadi is using it in a transformative way by using it to drive a search engine and not allow humans to actually read the text. So they're using it for different purposes, and that's a transformative use, and therefore it's a fair use. Second, the court found that Hadi's use of digital copies for blind and print-disabled access was a fair use. It held that although this wasn't a transformative use like the first one, the books are still being read, the format shifting for blind and print-disabled access was consistent with exactly what Congress had intended for fair use to be. For many blind and print-disabled, there's a very small set of books that are actually converted by the publishers. The rest is kind of left up to universities and others to make the conversions. So that's why fair use is really important to enable blind and print-disabled access. All right, so for both of these two uses, there was one key factor that the court highlighted, and I want to highlight for you. They highlighted the fact that Hadi had taken adequate security measures to protect the digital files. The court said if Hadi had not taken these measures to protect the content, then the decision may have gone a different way. So for those of you considering digitizing works for blind and print-disabled access, consider your security, consider your locks. Court just highlighted it, I'm highlighting it again. So there's the third use they were making, replacement copying. The court decided, the Second Circuit said that there wasn't enough information to make a decision. The record wasn't clear whether this had actually happened or whether it was ever going to happen, so they sent the issue back to the trial court to decide. So it's going back down to the district court. So next steps in this case. October 30th, there is a meeting with the judge. Judge has scheduled a meeting to meet with the parties to determine what the next steps are in this case. And the Authors Guild is going to have to determine whether it wants to continue litigation in this case. There's not a whole lot of issues left to decide. They're going to have to decide whether they want to appeal this up to the Supreme Court or not. Okay, last case, Georgia State. As with many universities, Georgia State made digital copies of excerpts of books available to students without securing permission of the rights holders. They usually put them on course management systems like this. This is actually my course management system for my course at Palmer Library School. Unlike most traditional course packs, these are digital copies stored on systems like Blackboard, on course management systems. And university professors believed their use to be a fair use. Somebody disagreed, and Georgia State was sued. In fact, these were the people who disagreed. The publishers of Cambridge University, Sage, and Oxford University Press sued GSU in 2008, alleging copyright infringement. We actually found out later that Cambridge, Sage, and Oxford weren't necessarily the ones who were funding this litigation. We found out in a footnote, actually, that the Copyright Clearance Center and the Association of American Publishers were actually the ones funding the lawsuit. If you know anything about CCC and AAP, CCC in particular makes money off of licensing works to universities and others, especially excerpts and small clips. So those are the ones who are funding it. So if we go back to the very beginning of fair use, before we even get to the four factors, the statute says this, and you don't have to read it. Let me just read a small portion of this to you. The law says the fair use of a copyrighted work, including such use by reproduction in copies for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research, is not an infringement of copyright. So Congress has told us that making copies for teaching, including multiple copies for classroom use, is not an infringement of copyright. So that's the preamble. Now we'll get into the four factors. So the district court starts to get into this and determines that the Georgia State's purpose of using these academic texts, these chapters, or maybe even longer, on their course management system was a nonprofit educational purpose. In fact, this is truly the nonprofit educational purpose that Congress intended. But it's not a transformative use. Remember, the purpose of writing the articles is for the articles to be read. GSU is using them in a way to enable reading, so it's not a transformative use. But the court makes an important point here that I want to highlight for you, that the uses don't have to be transformative to necessarily be a fair use. This is the use in scholarly, educational, nonprofit purposes is one that Congress values, and that's why it doesn't have to be transformative in this case. The judge also examined the nature of the copyrighted work, of the works that were copied, and determined that they were predominantly factual, that they were nonfiction works, and therefore we're not going to grant them as much protection as we would grant to something that is a very high level of creativity. So nature of the work, more factual, more nonfiction equals less protection. The amount used, the judge had a really complicated time here. There were a lot of excerpts. There was in fact 99 things that were identified as potential infringements. So the judge went through all 99 of them, or went through at least a good chunk of them, and tried to determine where the line was about how much you could use. And she came up with this formula that said that if GSU didn't use more than 10% of works with 10 chapters or less, or one chapter for books with more than 10 chapters, so no more than 10% if it's less than 10 chapters, or no more than one chapter for more than 10 chapter books, then it's not going to have, then the use is appropriate. Otherwise it's going to favor publishers. So if you use more than 10% or more than one chapter, that may cause a finding not of fair use. The other important thing the district court did was reject the classroom guidelines. For those of you in academic situations or academic environments, you've probably been saddled with this thing from back in the 70s that was the classroom guidelines that tried to describe what a fair use was in the educational context. So many people use those as ceilings and not the floors they were intended to be. So the court just outright rejects it and says, nope, that's not the law. That's not what Congress said. She also said that if there are licenses available from CCC, then those uses of that material may actually weigh in favor or weigh against a finding of fair use. So if the work is being licensed by CCC, putting it on a course management system without permission may actually harm the market for that work. So lots of different factors here. The opinion was actually a 350-page opinion. That's why it's a little complicated here. But of the 99 claims of infringement, only 5 are found to be infringing. Only 5. 5 out of 100, roughly. The judge ordered publishers to pay Georgia State's attorney fees because it was so clear that the university had won. And to give you a sense of how much it costs to litigate these things, Georgia State's fees, attorney fees, were over $3 million. So the judge determines that use on a course management system for all but 5 are going to be fair uses. As we've learned, there was an appeal back up to the circuit court. And 6 days ago, luckily we scheduled this plenty in advance, 6 days ago, the circuit court issued its opinion. This one is not 350 pages long, it's only 112 pages. With a 27-page concurrence, so long opinions. So this is it's a little complicated to break this down. It's there's a little bit of legal hand-waving going on here, but let me describe what kind of the headline. The headline is the district court's decision is overturned. The circuit court says that the district court's got to go look at this again. And it's kind of interesting how they did this. The circuit court instructs the district court to recalibrate some of the weight that she placed on various factors. There's 4 factors. She was placing weight in one way, and they want her to allocate the weight in a little bit of a different way. So it's not an outright rejection. It's not the court is not telling her that she messed up and that these are all infringements. It's just recalibrated and see what you get. So it's a little complicated. This case got kicked down, but it's not so bad. Although Georgia State lost the appeal, there's lots of positive language for libraries and culturals out of this. First, the court confirms the classroom guidelines are not law. So that's twice now we have courts telling us the classroom guidelines are not law. If you still use the classroom guidelines, you might want to look at this and maybe reevaluate. Second, the court reaffirms the importance of the nonprofit educational uses to the public good. The court describes how important it is to have these exceptions in place to allow for nonprofit educational uses so that we can advance knowledge and meet the goals of copyright law. There's lots more details here. This was 6 days ago and 112 pages, and we don't have time to go through all of it. But generally, this could have been a lot worse. We could have gotten an opinion that told us that all of this copying is illegal, that it's all infringements, and that we all would have to start all over again. That would not have been so fun. So not so bad. The next steps in this. So the circuit court has now told the district court that she's got to redo her 350-page opinion. let me tell you how much I'm guessing she doesn't want to do that. So at this point, there's probably a good chance that this case is going to settle. At this point, both sides have to pay for their own legal fees. So if GSU's legal fees are over $3 million at this point, I'm sure the publisher's fees are over $3 million too. So I'm guessing that a settlement is probably coming sooner rather than later. But we'll see. I always thought a settlement was coming before the circuit court, and it didn't happen, so we'll see how aggressive it gets. Okay, so we went through 3 opinions, lots of detail here. What does it mean for you today? What does it mean for libraries today? So I'll try to synthesize these 3 cases in a couple of quick bullets. First, libraries aren't losing. Since 1978, libraries and cultural institutions haven't been sued directly over copyright, at least until recently. And mostly that's because librarians tend to be thoughtful and risk-averse. Institutions, cultural heritage institutions, tend to be a little risk-averse. But even with that nature, they're not immune from lawsuits. But what we're learning is that litigation is not necessarily a successful strategy for rights holders. They're figuring out that they're not getting radical changes in copyright. They're not getting rid of classroom copying. They're not getting rid of digitization. So they're not getting the big wins that they want. So libraries are still able to serve users in the ways that we have, and we're learning that when these practices are challenged, that the libraries are actually, the practices are not infringements. The courts are increasingly recognizing the importance of libraries and how the things they do and the fair uses they make are important to serve society. The second importance that we're getting out of these 3 is a little bit of clarity around fair use. As I've kind of described, and hopefully you've picked up, fair use can be a little squishy. So one of my counterparts describes it as Jello. So if you put Jello in a Jello mode, it gets a little squishy, but you kind of know the shape of it. Jello, for those of you who might want to eat Jello, not so bad. But if you put concrete in it, if you try to harden up fair use, if you try to make clear, delineated boundaries, not so good. Most people don't want to eat concrete. So it's supposed to be a little squishy, but we're starting to get a little bit more clarity in the context of libraries. It's important that the uses libraries make are socially beneficial and advance knowledge, and some of those socially beneficial uses, including making text available for blind and print disabled. And they're also just using just enough of someone else's work to accomplish a pedagogical purpose. So that's helping to draw some lines around fair use. Another practice that's helping to draw some lines around fair use is these community guidelines of best practices. This is ARL's the Code of Best Practices in Fair Use for Academic and Research Libraries. It came out in 2012. And these decisions combined with these fair use statements, these best practice statements, are helping to give us some guidance in fair use law. Okay, enough of the litigation. Let's get into some of the legislation side. So increasingly, I'm finding myself engaged in copyright policy conversations. Now that Congress has started a review of copyright law, I'm increasingly finding myself in DC talking with legislatures about copyright issues. And this is all because of this person. In March of 2013, the Register of Copyrights, Maria Palante, delivered a speech at Columbia University entitled The Next Great Copyright Act. In the speech, she highlighted the fact that the last major overhaul of copyright was completed in 1976. In 1976, the technology of the day included this, and this, and this, and this. That was kind of lots of analog technology. So it's a 1976 bill written for the analog world, and we are no longer in that world. So the question is, what happens in the digital world? Well, we try to tinker around the edges. Congress has passed some things okay, some things really bad. But how does the creation, distribution, and consumption of digital media stress the current copyright system? How is it going to work? How should we fix it? Well, Congress is starting to investigate that. How do we fix copyright? So they've taken up her call and have been going through copyright law section by section. They've been doing this for a while now. The House Judiciary Committee's Subcommittee on Courts, Intellectual Property, and the Internet have started a series of hearings on reforming U.S. copyright law. They've held 17 hearings so far, and they're scrolling by, including the hearing that I testified at about the first sale doctrine. So next steps here. There are more sections to go through. We haven't been through the entire set, the entire corpus of the law, but the midterm elections have slowed down the hearing schedule. In fact, there aren't any hearings scheduled until after the elections. What we've learned, though, is on average it takes 20 years from the start of the review process to get past legislation, roughly. So we're starting 2013. We might have a copyright bill in 2033, maybe. But given conditions in Congress today, it may take at least that long, if not longer, because the environment's really toxic right now. So we have the fights against SOPA and PIPA not that long ago, a couple years ago, and we also have things like this. At a hearing on orphan works last March, the General Counsel of the Authors Guild said this about Google Books, and I'll note that this was before the Hadi decision that we just talked about came out. Hope? I'll try a different way.
Right, and they decided to just take trucks, dump everything in the back of a truck, whether it be public domain, whether it be in copyright, out copyright, in print, out of print. They didn't check whether it was disintegrating or whether there was any problem in preservation, and they just copied 20 million books in violation of the copyright. And if you think that that is fair use, notwithstanding the fact that two judges in a lower court have issued that, and it's yet to be decided by the Second Circuit or the Supreme Court, just wait for the next lawsuit that we bring against some of you who are using it in different ways than that are being used now by the Antitrust and by Google. You go one page instead of a snippet, we're after you. This is a violation of copyright law, pure and simple.
Go one page over and we're going to sue you. She also had this to say about the best practices documents and digitization in general.
If, as you say, everybody assumes in the best practices, which I take issue with, that you can do it without, with impunity, why would anybody exercise any kind of a license and pay creators for anything if somebody is telling them, do it, best practices? And again, I warn you, if I find out about it, I'm going to sue you.
We haven't been sued yet. We follow the best practices. But it's a really toxic environment right now, and their sides are so far apart that 20 years, if we get there in 20 years, it'll be amazing if we do that. One other issue involves New York State. So as we discussed at the beginning, there are two copyrights in sound recordings. There's the underlying composition, and then there's the sound recording. For sound recordings created before 1972, they aren't actually protected by federal copyright law. Sound recordings are not protected by federal copyright law they were created before 1972. Instead, state law controls. So sound recordings created before 1972 won't be in the public domain in New York until at least 2067. So the cylinder that I have in my office from 1900 will be in copyright till 2067 in the US. So 167 years, this thing will be in copyright. The other thing that New York law has is some criminal penalties for commercial piracy. So if you are a bootlegger and you are caught, you may have some criminal penalties in New York. There's a little bit of uncertainty in the New York state law, though, about whether libraries who do what they do about preservation and making things available would be caught in the net of this criminal liability. Are libraries criminally liable for doing what we've been doing for hundreds of years? It's an interesting question. In fact, it's a question that a few months ago the New York State legislature addressed. Well, almost. They nearly passed a bill that attempted to resolve some of these ambiguities. They had a bill that would exempt libraries, museums, archives, and other cultural institutions from offenses relating to unauthorized recording and distribution, unauthorized duplication and distribution of sound recordings. But they didn't resolve some of the civil issues. So you could avoid criminal liability, but you might still draw a copyright lawsuit. And if the sound recording industry is anything like the Authors Guild, who will threaten to sue you at any moment, not so good for libraries. The bill ultimately didn't pass, though. It got passed through the Senate, but died in the Assembly right before the end of the legislative session, so it didn't ultimately pass. But you're probably going to see this again. In fact, you're probably going to see it within the next 2 years in the next legislative session. And we're maybe interested in talking about how to fix this. So if you're at an institution who has sound recordings that are before 1972 and you're interested in digitizing those things and maybe even making them available to your patrons in some way, contact me. I want to talk to you. We may want to talk about how to fix this in New York. Okay, last section here, and then we'll start doing questions. So Europeana is a metadata aggregator. They've aggregated 30 million items from European cultural memory organizations over the last few years, so 30 million items in their database. The Digital Public Library is the counterpart to that in the US. DPLA is the acronym that I'll be using. It's essentially the US equivalent to this. There's over 8 million items in its database. They've been online now for just over a year. So they're getting there. 38 million items in total between the two institutions. And the question that users have regularly is, can I reuse this item? I've found one of the 38 million items. Can I reuse this? How can I reuse this item? Is this item in copyright? What is the item's copyright status? And we've had a really tough time of communicating that information to users. It's really tough to tell a user, yes, this is in the public domain, no, it's not, because there are some potential legal issues there. If you get it wrong, if you say public domain when it maybe isn't, that might be a little bit of a problem. So we're trying to figure out how to communicate the copyright status and how you can reuse assets in a way that makes sense for both the institution and for the user. Right now, DPLA has a little bit of a mess on its hands. Of the 8 million items in DPLA, contributing institutions have used 26,000 different rights statements to describe their assets. 26,000 rights statements. This is a visualization of those statements to get a sense of how messy all of this is. You'll see, though, they're kind of together in 4 quadrants, 4 clusters. One of them is in copyright, one of them is no restrictions, one of them is Creative Commons, and the other is unknown. So it's kind of a hodgepodge there. 26,000 different rights statements, not going to work for our users. So DPLA applied for a grant to figure out how to solve this. And in fact, they got the grant. They got $300,000 from the Knight Foundation to simplify these rights statements. The goal is to create a menu of rights statements that culturals will feel comfortable using while describing assets in a way that's useful to patrons, to users. The goal is to make these statements available worldwide and to be used worldwide. So there are 172 odd copyright laws in the world. How can you describe the copyright status of an asset in a way that works for every country? A little tricky to figure out. That's why they got a $300,000 grant to do it. So Europeana, DPLA, and other representatives, including me, are working on these now. Our first meeting was a few months ago in New York to figure out a basic outline and whether we can actually accomplish this goal, and we think we can. We met last week in Amsterdam to figure out how to accomplish that goal, and I think we're making really good progress towards it. So forgive me if I'm a little jet lagged, but that's what that's from. All right, so next steps from this DPLA side. The goal is to develop the menu of options and to develop a paper discussing the issues and discussing the options that we've come up with. We'll release it for public comment maybe as early next spring, for public comment. We want to figure out whether we got it right. There's 20 of us sitting in a room, and we want to make sure that we've got this nailed. And after we get the comments and we make adjustments, we'll implement it so organizations like NYPL or even the Empire State Digital Network can use those statements to describe their assets in a way that everyone understands. So everyone understands what public domain means in a way that makes sense. That's our goal, and we'll get there soon. So those are the 4 sections that I have for you. I'm happy to take questions. We have about half an hour to do questions. I know we covered a lot of material. I cut a lot out, but copyright law is certainly changing rapidly at this point, and some of the changes are really incremental. Some of them may be really big, like the congressional changes. So happy to take questions.
Could you tell us a little bit about the Teach Act, because that concerns universities a great deal, how much leakage?
Yeah, so Teach Act really isn't changing anytime soon. Teach Act gets a little tricky to get into in this kind of environment. There's a lot of really nitpicky rules you got to follow. There's actually a really good guide. Baruch put out a really wonderful product to help professors get through that decision tree. And if you look for it, it's on Baruch's site. It's a wonderful tool for professors to navigate the system, to make decisions and understand the risks and go from there.
What tool is that?
It's Baruch College.
Baruch College.
Yeah. Do Google search. It's wonderful. Yes.
Well, I had a question also about the TCHAC, but more specifically about section 110, which is the classroom. And when you read this, and maybe I'm misreading it, they're talking a lot about non-for-profit institutions. Right? So what happens when, for example, an institution is private and clearly for-profit?
Yeah, they don't get to take advantage of 110. They don't get to take advantage of some of the exceptions in 110. They've got to rely on other exceptions and limitations, maybe fair use, maybe others.
So what trumps the licensing that, let's say, Harvard Business Review puts out in terms of using digital resources or fair use?
Yeah, that's a scary thing. So we just spent an hour talking about copyright law, and all of the exceptions and limitations we just discussed, you can waive with the swipe of a pen. Licensing trumps. So a contract will always trump copyright law. If you give away your fair use rights when you sign an agreement, you've given away your fair use rights. You don't get them back unless you figure out a way to get around the contract. So contract always takes over. That's why when I testified actually about first sale, one of the ideas that we proposed was to have a preemption so that libraries and archives wouldn't be able to give up those rights. That the copyright law, the exceptions and limitations in copyright would always trump the contract, not the other way around, which it is today. I don't know if we'll have good traction on it. We proposed it, never heard anything back. Yeah.
Sorry, we were just saying, how is the preemption going to work?
Yeah, so the idea is that if there's an exception and limitation in copyright law, you can't give that away in a contract, that you wouldn't be able to waive it. So if you signed a contract that said, we will never, ever, ever show this to, I don't know, Joe Schmo, that wouldn't be enforceable because first sale would allow you to do it. Yeah.
I have two questions. When you showed to me more, pregnant and everything, if somebody else, I know that you showed us the man that would, for the joke, but if another woman was pregnant on a magazine or whatever, then that would be an infringement of, if it wasn't him and it was another woman that was in that pose, that would be an infringement of copyright?
Maybe. We have to go through the 4 factors and determine whether it's a parody. In this case, it was a parody,
Right.
so there was no question. But there may be some copyrightable elements.
And because she's
Yeah.
pregnant?
Yeah, the photographer may be able to assert rights in the way that it's posed, her expression, any of those things might be elements they could copyright.
Okay,
They
and
assert.
I have another question too, about the libraries and archives. I missed a little bit of that. You said there could be copying for preservation. Oh, that one.
Yeah.
Can I
So
read that?
sure. So copying for preservation, copying in response to patron requests.
Right.
So we get a lot of patron requests for copies. Making copiers, computers, and printers available for patrons. So if we didn't have an exception, we may have a little bit of liability for the things that our patrons do on our copiers. So having an exception in the law that prevents that from happening enables most institutions to do it, and even permits some broad uses of older orphan works. So works for which there is no rights holder available or present or will claim copyright. The law allows libraries to make lots of uses of that material in the last 20 years. No protection. Yes.
One question I have is more like digital derivatives created from like public domain works. Whoever makes the digital the digital version owns the copyright.
Good question. So in this circuit, in Manhattan at least, there's a decision by the Southern District of New York that says that the mechanical reproduction of an item does not engender a new copyright. So NYPL, when we photograph items that are in the public domain, we do not get a new copyright in that photograph. So when Pete does this, we don't get to claim a copyright in his photograph. Because what he's doing is trying to slavishly reproduce the work in the most accurate way to do it. I'm not denigrating what he does. This is a really professional skill. Reproducing these things at this level takes a lot of skill, but there's no creative element there, or at least there's no recognizable creative element that we're willing to protect. So at least in the Southern District, there is no copyright. Now, a lot of institutions, a lot of museums try to claim a copyright in that photograph. And maybe that's true for three-dimensional works because you've got to pose the thing, you've got to figure out the right angle and the right lighting. But for things like this, two-dimensional works, no new copyright. And other institutions, other libraries are following this decision and not trying to assert new rights in these things.
Outside of the Southern District of New York, though, it would be
Maybe. No one has litigated the issue, or at least no decision has come of one of those litigations. So I would bet that the decision is going to be that there is no new creativity in this, regardless of where you are in the Southern District or in California. Yes.
If an article is available, say, from JSTOR full text, does it follow from that the instructor of that institution can make copies and distribute them?
Depends on the licensing agreement with JSTOR. So I haven't read the JSTOR terms and conditions in a little while, but I'm guessing there's something in there about making reproductions and copies available. There may even be a license in there that says that professors can make those copies available for their users. What I suspect, though, is that if it's on campus, if anyone in the campus can access a JSTOR article, then the best practice is probably just to link to that JSTOR article and not necessarily reproduce it and put it in a course management system. Yes?
If a library actually creates a derivative and they do this like a significant amount of preservation work on that, like correcting the video or something, could that allow them to claim copyright on it?
Maybe if there's creative elements there, but if they're just trying to reproduce and preserve the original, maybe not. So, and for me, my job is to increase access to material as broadly as possible, which means that we don't want to claim new rights in these things. If we claim new rights in these things, then we're probably impeding the dissemination of the information. We also have to deal with licensing, and none of that is very good for our users. So we try to avoid it as much as possible. And when we do own copyright in things, we just actually released a bunch of material that's on HathiTrust that NYPL owned a copyright in. We made it available under a Creative Commons license that enables anyone to reuse it any way they want without talking to us first. So we're trying to expand that access.
What is the situation like a particular library has posters which they purchased and it's of a time period between 1940 and 1960? And now considering the popularity of it, they would like to digitize it. They see that these posters have a lot of joint efforts in it. There's somebody who's done the artwork, some other company has produced this. Now, they're not sure, they purchased this, are they supposed to get all these clearances or show that they have tried to get some clearance or whatever, and then proceed with the digitization or whatever of these posters. And here comes along some other person who says, hey, listen, I just saw this and I would like to have a copy of this. Now, what happens?
You're getting really close to that line. I can tell you generally, though, that's really a risk analysis question. I mean, that's whether a library thinks they have to do it or not, or whether they think there's a risk that someone will complain or not, is kind of a decision that every library's got to make on their own. For the most part, libraries have been risk averse. NYPL was risk averse for a long time. We weren't digitizing material created or published after 1923 for a long time. I started almost 4 years ago, and we stopped doing that. We now digitize all the way through 89. In fact, we digitize things that were created very recently under we get a license or something. So it's really a risk analysis question and less of a copyright kind of question. There are ways around that, though. I mean, you can look up some of the duration rules. Copyright is not necessarily as nice and clean as I made it out to be on the duration rules. Sometimes there are ways to get around some of these things, especially material created before 1964. Yeah. Any other questions? Yes?
If a library uses a digital copy and the copyright is undetermined, is fair use something you want to have it available to patrons on site only? Is that
Yeah, it's another risk question. I mean, you could make an argument for making it available on site is a fair use, especially if you can figure out an argument within the 4 factors and discuss why that use is a particularly beneficial use. You will find content on NYPL's website even that the copyright status is undetermined. We've just made a risk analysis decision and decided to make it available online because we think that it's either a fair use or we're protected by some other exception or limitation. So it's really, there may be copyright issues there, but it's really a risk question. And that's a lot of what I do. I mean, what we do in libraries today is we figure out the copyright issues, we figure out whether there is a copyright or not, or maybe undetermined, figure out what the risk is, and then make a decision. Yeah.
So how did you figure out that the Authors Guild lawyer was bluffing?
We don't know yet. She hasn't sued us.
It's an expensive mistake, right, if you're wrong?
It is an expensive mistake. So if the maximum statutory damages on a copyright infringement is $150,000 per infringement or per work infringed. So we've digitized at this point over 1 million assets. So at 150,000 a pop, we're in the billions, if not a little more. Yeah. So yes, there are certainly significant risks, and that's why libraries have been risk averse. But there are times and places to make those decisions, and it's not like we close our doors and don't let our patrons in because we're worried about a slip and fall. Right? There has to be some risk taken to serve the patrons, so that's why we're willing to do it. I testified actually before the Copyright Office at that same hearing that the Authors Guild president was there. I testified about NYPL's collection of material from the New York World's Fair from 1939 to 1940. We digitized something like 20,000 photographs from that collection. I spent 2 days looking through the archive. Luckily, we have the corporate records at NYPL, so I went through the corporate records to determine whether any kind of copyright assignment or any kind of if anybody cared about the copyright before the corporation shut down, and it looked like nobody did. So I think those are orphaned works. So we digitized 20,000 of them. Now, if I'm wrong, if some copyright holder comes out of the woodwork and goes after us, 20,000 times the maximum statutory damages is 150,000. It's expensive, and that could be a major mistake. But it's something we took a real reasoned analysis, a real careful approach, and determined that that risk is very small.
I'm glad you're doing it.
Thank you. Yeah.
Practical question. If the library is thinking about, like, let's say, a small-scale digital project, would you recommend, like, I don't know, they digitize it in the book cover or taking photographs of the objects and put them in a library catalog? Would you recommend consulting first this code of best practices and understanding what we do, and then would you also recommend, like, after examining this book to, I don't know, consult the legals of the university? So, like, what will be the steps, so?
Yeah, I think that it's first figuring out what the risks are. What are we really talking about? Are those works actually in copyright? Are they out of copyright?
So this book, the code of best practices, will be the first to examine before you run out.
Well, the best practices are assuming the work is in copyright. So the Copyright Office actually has some really good really helpful pamphlets to describe how to determine the copyright status of an item, determining when it was published, things like that. If it is in copyright, then those best practices documents are helpful to some extent, so long as your project is in that. But in any case, like I'll said at the beginning, I mean, it's a legal issue, and if you're not comfortable with it, talk to an attorney. Or even if you are comfortable with it, sometimes it's helpful to talk to an attorney. Yes, in the back.
Digitized from like obsolete formats. Is that fair use?
So there's a couple of ways to do it. Fair use is one avenue always. The other avenue actually is Section 108 in the Copyright Act. Section 108 says that in some situations, obsolete formats can be reproduced for preservation purposes, to format shift them into a preservation format that works. For example, HD DVDs. Nobody actually remembers that those things are actually obsolete now. HD DVDs, there are no more players being made. NYPL has a nice collection of HD DVDs that we can't do a whole lot with because there's no more players. So we have been going through and format shifting them because they're obsolete, and we think we can do that under 108, or at least pieces of that, or fair use. Yes?
Yeah, it's probably a question outside of copyright laws, but What's the thing, Creative Commons?
I think Creative Commons is wonderful. So, like I said, my job is to increase access to material as broadly as possible. Creative Commons is a way to reduce one of those barriers. So we're always worried about what the copyright status of the item is and whether we can use an exception limitation to it. If there's a Creative Commons license applied to that object, I can skip all of that conversation and know exactly what I can do with it. It's a wonderful thing for libraries who want to get information out and who own rights and things, and it's also a way for libraries to use material that they would normally not be able to or might not be able to because they're afraid of risk. Wonderful thing. Yeah.
I'm getting back to the gentleman's question about obsolete formats, right? And say, for instance, a company comes up, which has provided something in an obsolete format and now is providing it in a newer format. But they want to charge us for it. And we feel that we paid all this money for it. And so we have the right to take whatever segment or whatever we want from it to be able to digitize.
So, again, that's getting really close to legal advice. But what I will tell you is Section 108 does have some good has some clear guidance about that, about whether things are commercially available or not. And really, that's probably too in-depth of a conversation to get into here. But Section 108 probably has some guidance on that. Any other questions? Cool. Well, thank you for your time tonight. I know it's gotten a little warm in here, but thanks for everything.